Now to a Global News exclusive. A BC man charged with second-degree murder and attempted murder in a high-profile homicide has been acquitted. A BC Supreme Court justice ruled investigators with the province's Special Homicide Unit disregarded Canadian law when dealing with key pieces of evidence. As Jordan Armstrong reports, now there are questions about whether other criminal cases will get their day in court.
Samandeep Gill is a free man. After almost 3 years behind bars awaiting trial, the accused has been acquitted on charges of second-degree murder and attempted murder.
I can say without exaggeration, I have never seen anything like this before.
Back in April 2011, just hours after they were married, Manbir Kajla and his wife were involved in a fender bender in Surrey, BC. When Kajla got out of the vehicle and approached the other car, he was shot by a suspect who then left the scene. Gill was charged in 2018, but the murder case crumbled after key Crown evidence was thrown out last month. Alleged audio of the shooting captured on a cell phone seized by the RCMP's Integrated Homicide Investigation Team, or IHIT, from Gill's home, deemed inadmissible.
Basically flouting the law, of deliberately disregarding the law in what appears to be almost all of their cases across the board for a matter of years.
At issue is compliance with Section 490, the law that police must seek extension orders to hold evidence beyond 90 days. In court, it was revealed that IHIT was warned as early as 2007 by Crown and a Justice of the Peace not to ignore that section. In acquitting Gill, the judge found the blanket noncompliance policy continued beyond 2014, when IHIT supposedly dumped the directive. The IHIT policy of noncompliance amounts to systemic, flagrant disregard for charter-protected rights, said the judge. I find that IHIT was, at best, willfully blind towards the charter implications of the policy. The fact that the police in this case sought and received legal advice that explicitly deemed compliance mandatory makes these actions more egregious. We reached out to all levels of the RCMP, including national headquarters in Ottawa, to request an interview, but we did not get one in time for this story. In an email, the acting boss of the homicide team said, "I can confirm that IHIT has since taken steps to ensure our investigative standards and actions align with and are compliant with Section 490. She adds they're talking with BC's prosecution service on how to move forward.
These are not guidelines. This is the law.
Vancouver lawyer Ravi Hira can't speak about the specifics of this case, but he says newly uncovered information could be a tool for the defense in homicide convictions still under appeal.
If an agency deliberately elects, not to engage in that which is required by the law, in my opinion, that investigative agency is playing Russian roulette with evidence.
Jordan Armstrong, Global News, Vancouver.